So for today's seminar, we are very privileged to have three excellent speakers who will speak for roughly 10 minutes each, and that will leave ample time for the Q&A at the end. So firstly, we'll hear from Anna Watchman. Anna is our Community Advice and Research Coordinator at the Centre, and she's going to speak about her research that's been exploring the needs and experiences of women involved in the criminal justice system who have come to court. And this research is part of a wider piece of work that's been funded by the Aurum Charitable Trust that looks at how we can improve the court experience for women. And then next, we'll hear from Lucy Slade. So Lucy is the Centre's Policy Officer, and in 2022, Lucy was accepted onto the Griffin Society Fellowship Programme, where she examined the experiences of women with caring responsibilities and the experiences that they have of the court process. So she's going to be sharing about that research today. And Lucy's findings are an important start to the conversation about the shape of reform needed for women and their children who come through our courts. And then lastly, we'll hear from Katy Swaine Williams. Katy is an associate of the Centre and a freelance research and policy consultant specialising in criminal justice reform. Katy was recently appointed to the Independent Women's Justice Board by the government, and she plays a pivotal role in shaping efforts to reduce women's imprisonment. She also leads initiatives at the Centre for Women's Justice and Hibiscus. And so Katy today is going to speak about the experiences of women as defendants in court, who are also survivors of violence against women and girls. So then lastly, I will then open up the Q&A. So again, please submit your questions throughout the event on the Teams Q&A function. You can find that tab at the top and then that'll be ready for the Q&A session. So we hope you enjoy. Now over to you, Anna.
Hi, everyone. I'll just wait for my slides to come up. Perfect. So my name's Anna, and I was a research intern with the Centre at the end of last year. And while I was doing that, I took part in a project exploring the needs of women coming into the criminal courts, how these needs can impact how women engage with the system, and how we can begin thinking about how to address these needs and improve the court experience for women. Next slide, please. So I will give a little bit of a project overview and then talk about some of our findings. So what are the needs of women coming to court, why it's important that we consider women's needs, and how we can improve the court experience for women. So this was an exploratory piece of work using mixed methods. So this included conducting a literature review and recognizing that there is a growing focus about the needs of women in the wider criminal justice system, but there is a real evidence gap in this early stage of the court system. So we conducted 6 interviews, and these were with practitioners who support women in a variety of roles, supporting women who come into court. So this included a defence solicitor, a senior mental health practitioner in the liaison and diversion team that's based in the court, a witness service volunteer, the managers from a court-based advice service, and a family justice practitioner. We also examined data from a court-based advice service who support women with a variety of needs. So these are things like housing, debt, health, benefits, domestic abuse. And we also conducted a number of court observations, particularly looking at cases where women were the defendants or witnesses in cases, and these were conducted in a busy inner London court. Next slide, please. So we recognise that women in the wider criminal justice system, they often experience multiple overlapping disadvantages, and this was largely reflected in this research. So the findings are kind of similar for women who are coming into court. So as I mentioned before, part of the research was looking at data from these court-based advice services, and the data from this slide is from an advice service that runs a small number of magistrates, advice services in a small number of magistrates in Devon and Cornwall. So we can see that 1 in 3 of the women who engaged with these services had 4 or more multiple support needs. So they were experiencing challenges in multiple areas of their lives that they required support around. And yeah, some of the common needs we can see were mental health, accommodation, domestic abuse, benefits, debt, and substance use. Next slide, please. So a little bit more about the needs that women are experiencing. So yeah, we've got things like housing, care and responsibilities, domestic abuse, mental health, and we can see that these were impacting a lot of the women that were coming into court. So for instance, housing, over 1 in 3 women who sought advice from the practitioners had needed support around their housing. And sometimes this was directly related to the case that they were involved in. So for instance, women who are experiencing domestic abuse, who needed to be moved for their safety, or in cases where there were things like neighborhood disputes. Another key one was caring responsibilities. So around half of the women who were seeking support had caring responsibilities. And research shows, including my colleague who's going to speak next, that caring responsibilities are disproportionately impact women. And practitioners in their interviews often reflected that these are likely underreported, their caring responsibilities, and that would be to do with things like fear of social service involvement. And reflected opposite in this quote. So this came from a defense solicitor, and she basically explained that in certain instances, women might, for example, plead guilty, or despite being innocent, or despite there being mitigating circumstances, which, if it meant that the case would be over much quicker and they could return to their children, even though this wasn't the best outcome for the women. Next slide, please. So why is it important that we consider women's needs? So we know that women are underrepresented at all stages in the criminal justice system, and this was largely reflected in our court research. So similar findings here. Kind of anecdotally, when we were doing our court observations, we sat through lots of them, and a very, very small number were women as defendants. We know that women commit crime for different reasons than men. So often it's acquisitive crime, so to do with poverty or providing for children. We also recognize that not considering or addressing the reasons why women are committing crimes often leads to women being trapped in a cycle of reoffending, returning to court, and often progressing further into the system. Next slide, please. So some things that emerged, some areas that would be really key to look at to start improving the court experience for women. So one of them was removing barriers to effective participation. So we know that it's essential that individuals should be able to understand and participate in their case, because this leads to them interpreting the process as legitimate and fair, and less likely to contest decisions and more likely to engage with sentences. But things like unaddressed needs such as substance dependency, mental health, language barriers, all of these things can cause distractions, difficulties concentrating, and ultimately impact how someone can effectively participate in their case. So one of the areas it's important to focus on is addressing these barriers, and things that came up were improving interpreter and advocacy services and improving the accessibility of information. Also key to look at is improving access to advice and support services. So court should be an opportunity to intervene and support women to break this revolving door and begin to address some of the disadvantages they're facing. What emerged during the research was the power of the court to facilitate access to services. So not only just by encouraging and signposting people that come into court to these services, but also, for instance, like mandating treatment requirements. So practitioners often fed back that women who'd, for example, been mandated to engage with mental health treatment requirements, they were able to access these services much more easier than if they tried to access them in the community, and ended up on long waiting lists. We also recognise that contact with the criminal justice system is traumatising in itself. So it's really important that we adopt trauma responsive approaches. And some of the particular areas that came up to focus on was the court environments, the gathering and sharing of information between professionals, and the accessibility to things like special measures. Next slide, please. I'll very briefly go through these But we were just looking at some areas of good practice that begin to remove some of these barriers and challenges, and reduce, some of the challenges that women are facing. So obviously I've spoken a lot about the court-based advice services, but these are really good opportunities for women who may not have ever been able to access support before. The fact that they're based in court, it might be the first time women have had contact with services, and the fact that they are independent from the court breaks down some of those barriers to engagement. But despite being a really essential service, they're only based in a very small number of courts in England. And in the research, we actually came across a female-only court service, advice-based service, that unfortunately lost its funding, despite the incredible stuff that it was achieving with some of the women that were using the service. Another area that's getting a lot of focus is women's problem-solving courts. And these are obviously an incredible alternative to custody, but again, there's only a small number of them in England, and they have a very strict criteria due to resources, so they're not accessible to the majority of women in contact with the court. Next slide, please. So what's next? So we'll shortly be holding a roundtable for practitioners working within the courts to explore the way in which we can begin to address women's needs and improve their experience of court. And we will be publishing some of the findings about the project and some of the next steps. So thank you very much. That's my email, and I will hand back over to Vicky.
Thanks, Anna. Thank you. That's a helpful overview of kind of findings and lots of issues there that are kind of facing women, or that are distinct to women, that for many people on the call who have been working in this area for a number of years, it will be absolutely no surprise. But I think it's interesting to start having some of those conversations around, we know these issues, so what can we do to actually try to tackle and address some of these differences that are impacting women. So thanks, Anna. Okay, so we're now going to pass over to Lucy, and Lucy is going to talk to us around how women with caring responsibilities experience the criminal court system.
Okay, I'm just going to put my
just a reminder to people to please do pop questions in the Q&A throughout presentations, please, and we'll come to those at the end.
So in my day job, I work at the centre in the policy team, but I had this opportunity and an absolute privilege to conduct some research as a fellow for the Griffin Society research programme. And I'm going to talk through the findings of this research. So anyone who's ever been to a court or knows anything about a court will know that it is a greatly inconvenient process for anyone to engage with. You're not given a specific time for your hearing. You can be waiting for hours. You might have to come back to somewhere far from your house many times. And I set out because I wanted to understand if this system, which is a nuisance for most people to engage with, is set up in any way to accommodate the needs of women, particularly women with childcare and caring responsibilities, which we know, as Anna's just spoken about, we know women still disproportionately undertake this in society. So the Equal Treatment Bench book served as a reference point for my inquiry. It has its judicial guidance, and within it, it states that the interests of justice are unlikely to be served by a witness or party being late or distracted because of worries over childcare. And it calls for the court to accommodate as far as reasonably possible these responsibilities. So I set out to understand if this standard is being met in the criminal courts. I conducted interviews with 12 women who had attended criminal court. It was a mixture of magistrates and Crown. The majority of them were defendants, but I did speak to 2 women who were giving evidence as witnesses. All of them were mothers, though one was a mother for her adult daughter that she was a carer for. And they lived across 5 different regions across England. So I'm going to go over a summary of that top line of my research findings from these interviews. So many of the women I spoke to said that the way the court cases were listed made physically attending their court hearing really difficult. The lack of choice over the date, not knowing the exact start and end time of the hearing or trial were cited as real issues to be able to get there, particularly for women whose children were in school. And as interview 1 summarises this problem, she said, "I was nervous because I didn't know how long it was going to take. would I be back in time to collect my son from school? If not, who could I ask? Because then I have all this to worry about. Delays to court hearings also created further problems. Some women described having to frantically rearrange childcare from the waiting room, and described really feeling constantly being in a state of anxiety about when they could leave. And interviewee 3 was in this exact situation. Her hearing had been delayed, and she made the decision to leave court to go and pick up her children from school, even though she knew it meant risking arrest. This had really serious implications for her case. And rescheduled hearings or trials led to similar issues for some of the women. So again, interview 1 told me, I'd taken time off work and I have to arrange for somebody to come and stay or to collect him from school. But again, I had to cancel that 3 times on the day or the day before that it actually happened. And many of the women I spoke to talked about the real lack of facilities for their children at court. There was a mixed understanding if they were allowed to bring their children with them at all. And the waiting room was described as being really not appropriate for children. It was cold, intimidating. There was nothing for their children to be entertained with, which interviewee 4 contrasted this to doctor's surgeries, which has books and toys. And this is a space they could potentially be spending hours with their children. And interviewee 11, she was a witness in a trial, and she asked the witness service if there was a creche service where she could leave her children while she was giving evidence. And not only was the answer no, she actually felt like she was really being laughed at for even asking in the first place. And it was felt that there was a real lack of consideration that being a primary carer may impact their ability to engage with the process. As interviewee 10 said, at no point was I asked if being a carer would affect my attending. I was just told, these are the dates you're going to have to attend, end of story. And there was a consensus throughout many of the interviews that there was a real lack of practical support throughout the court process to find a solution to the problems that they were encountering. They described a really similar attitude from the solicitors, from police, judges, magistrates, the witness care unit, that really, we can't do anything, you are just going to have to make this work. This interviewee 2 said, if you call your solicitor and say, I've got no childcare or I can't get there, the main sort of response is, you really need to get there because otherwise you're breaching bail. They'll issue a warrant, then you're going to get arrested. And I heard from so many of the women who attended court as a defendant that behind this lack of support, they believed that the attitude was that they were deserving of their problems. They felt incredibly judged for being a mother in the justice system, which took a toll on their mental health and their self-worth. But it also made some women just keep quiet about having children at all. They didn't want to talk about the problems they were facing and just get in and out as fast as possible. And that was how interviewee 9 felt. She described the attitude as, that's for you to sort out childcare. That's not our issue. You shouldn't have committed these offences. It makes you feel like a scummy, shitty person. I also had a variation in these experiences of attending court. It wasn't the same every time. And it could really, they described feeling that it could depend on the judge or magistrate that they saw. So for example, interviewee 2 had a really positive experience where a judge ordered probation to go to her home to write up a pre-sentence report so her children wouldn't be, in her words, dragged to court. And another example I heard was from interviewee 7, whose child was sick on the day of her hearing, and her solicitor was able to rearrange it without any problems. But these positive examples of support were very much in the minority. And for nearly every woman I spoke to, the only way they could physically get to their hearing was relying on families and friends to support with childcare, which for some of the women, some of the time, that was arranged without issue. But even in these cases, similar expectations and pressures were put on the women's support network, as was the case with interview 11, who was told by the police that her sister would need to take a whole week off work to look after her children because they couldn't give her a specific date when she would be giving evidence in a trial. And even where this support network was in place, still a number of barriers existed to being able to access that support. For example, 2 women had children with additional needs, which made finding suitable care difficult. It couldn't just be anyone that could look after their children. And 2 women told me about the embarrassment that they felt going to court meant they didn't feel able to ask their family or tell anyone in their lives what was going on, the people that could help them. And it was interesting, it wasn't just defendants. It was one was a defendant, but one was also a witness that felt like this. And then we've got a quote to show that. She said, "You can't rack up your kids with you. So what are people supposed to do? Like, I certainly wasn't going to tell my dad when I was going to court because I couldn't. So I wouldn't have been able to ask him." And of course, some women didn't have a support network at all. Some of the women were single parents, they'd grown up in care, or they'd recently moved away from where their family and friends were living. So the impact of this experience took a real serious toll on women's mental health in the run-up to their court appearance. And this was particularly acute for the women who faced the possibility of receiving a prison sentence and the possibility of being separated from their children. And they spoke about this being much worse because they knew that if they did receive a custodial sentence, they would be sent straight from court to prison and they wouldn't be able to tell their children what happened. And that was really playing on their minds. As was the case for interviewee 6, who spoke about feeling re-traumatized by the prospect of going to court for sentencing, as she'd already lost the care of 2 of her children and faced losing the care of her baby if she received a custodial sentence. And she said that on the morning that I had to leave her, because I thought I was going back to prison, I couldn't sleep the night before. And that's when I got in the taxi to go to court. It was horrible. I just couldn't stop crying. And several of the women spoke about how the lack of accommodation from the court process and the fear of being arrested had on occasion meant they had to make difficult decisions, which put their children in situations that they were not comfortable with. They really stressed. They were never in danger, but they were not being looked after by the most ideal people. I heard stories about children being looked after school by teachers, by elderly and disabled parents, and in one case, even prison guards, who stepped in, did their best, looked after their children until the women could return from court. Interviewee 2 said, "I do remember on one occasion having them sat in the car park, running in and out, my friend in the car, they'd break for lunch, you've got to go back up and go, I'm still not in yet. The children are getting arsey and ratty in the car and everyone's having a meltdown and you've got to go back in." And this had a really serious impact on the ability of these women to concentrate during the proceedings and take in what was happening, as their children's welfare totally consumed their thoughts. Interviewee 6 said, "I didn't concentrate at all I kept thinking is she's going to need feeding in a minute, and I just didn't take it in. I wanted to get back down to the cell and get going. All I could think about was her. I didn't really pay attention." So in conclusion, my research indicates that the standard in judicial guidance in practice is not being upheld. And it's clear that the system needs to respond to these women's situation and their needs well before they appear before a judge or a magistrate. And this is just a small group of the recommendations. There are more in the report, but I think that even just some small adaptations could make a really big difference. Asking about dependents in the first place, including on the court summons contact details for help when difficulties arise, possibly paying for childcare. I believe vouchers do exist in the family courts. This could be applied to criminal. There are also existing powers in the justice system that already exist, which some women did encounter, which made their ability to get to court easier, which could be widely more used, such as home-based court orders, making greater use of video links, and looking at out-of-court resolutions, looking at whether the cases, especially for the women attending magistrates' courts, could they have been resolved without going to court? And then the more structural, long-term changes that would positively impact women's experience of court, exploring whether we could pilot a scheme which had set times for court hearings and trials, and also reviewing the post-sentencing arrangements for people with caring responsibilities who receive a custodial sentence so that they can contact their family. And that is me done.
So much, Lucy. I think, again, it's just really quite devastating and stark to hear from those kind of testimonies from all of those women that contributed to your research there around the impact on them and their children. So, yeah, thank you for sharing that. We're going to hand over to Katy Swaine Williams next, and Katy is going to talk to us around the experience of women as defendants in court who are also survivors of VAUG. So over to you, Katy. And as just a reminder, please do keep putting, I can see some questions coming through to the Q&A, so please do keep adding to those, and we'll come to those next. Thanks, Katy.
Thanks very much, and thanks for the invitation to speak. I should just say to start with, I think Anna and Lucy's research is incredibly important, and I do agree with Anna that this is a sort of underlooked at area in many ways, but as we can see, the problems are really basic. Yeah, I hope it's going to get a lot of traction, and that I know that we've got some officials here today, but yeah, I hope that there's going to be opportunities to share it a lot more widely. My presentation is based on my work with Centre for Women's Justice, which is a lawyer-led charity that aims to tackle discrimination against women in the criminal justice system. And I lead CWJ's criminalisation project, which is focused specifically on pressing for reforms in law and practice to prevent inappropriate criminalisation of victims of violence against women and girls. And the issues I'm going to talk about today are covered in detail in a book chapter that I wrote for the Edward Elgar Handbook of Domestic Abuse, published last year, which is listed in towards the end of the slides alongside some other resources. Next slide, please. So public debate about the links between domestic abuse and women's offending have tended to focus on women who kill their abuser and are convicted of murder, when in fact they may have killed their partner in self-defence or as a result of diminished responsibility or loss of control after years of abuse. And the difficulties faced in those cases, including during court proceedings, are set out in some detail in Centre for Women's Justice's 2021 report on women who kill. But of course, the number of women who kill is tiny, while thousands of women go to prison each year. And the majority of those are victim survivors of domestic abuse and other forms of VAUG. And we know that for many of them, their offending is directly linked to their experience of abuse. And that's acknowledged in the Female Offender Strategy quoted here, which was in turn informed by the Prison Reform Trust's 2017 report, There's a Reason We're in Trouble. But since 2018, very limited progress has been made to improve the support and protection available to these women before, during and after criminal proceedings against them. And that's partly due to the lack of adequate and sustainable funding. And of course, there's actually been a reduction in funding in terms of the criminal court system. But it's also because of a lack of strategic focus on these women as victim survivors, that's within the broader context of women as defendants in general. Next slide, please. Elizabeth was raped at 16. She turned to drugs. She met a boyfriend who abused her. He forced her into his business, carrying drugs for him. One day, covered in bruises, she was arrested. She wouldn't speak, too scared of what her boyfriend would do. So the police pressed charges, and Elizabeth ended up in court and was imprisoned. CWJ's Double Standard and No Safe Space reports set out in detail how gaps in law policy and practice mean that victim defendants, like Elizabeth, don't have their experience of abuse properly taken into account in proceedings against them. And that can occur where suspects are not identified as being victims of domestic abuse, or as in Elizabeth's case, it may be that the abuse is actually known about, but there's a failure to investigate that and to ensure that the evidence of the context of abuse is properly taken into account in decision making all the way through the process. There's also no effective mechanism to challenge inappropriate prosecutions in these cases. And to add to that, as Anna and Lucy have alluded to, safeguards that do exist in court proceedings aren't actually sufficiently used to enable victim defendants to give their best evidence in court. The Lord Chancellor's decision to tell Elizabeth's story in her remarks launching the Women's Justice Board in January indicates that the government has an ambition to get to the bottom of this. But the test now is going to see how that's translated into strategic reforms. Next slide, please. Anna's gone through some of the evidence about the characteristics and needs and circumstances of many women in contact with the criminal justice system. We know that most criminalised women are also suffering poverty, mental health needs and harmful substance use. And of course, domestic abuse and VAUG can affect absolutely anybody, whether or not they're facing those other problems, as can criminalisation. The real difference for Elizabeth in the case study was made by receiving support from the charity Women in Prison, and research shows that involvement of women's specialist services is often what makes the difference. So those services supporting her without judgment, helping her to engage with social services, advocating on her behalf to police and prosecutors, contributing to pre-sentence reports, working with probation to try and ensure that her situation is known about and that she's treated fairly. Next slide, please. Access to support and access to justice are particularly difficult for Black, minoritised and migrant women who are overrepresented in the criminal justice system and require specialist service provision and an intersectional approach. And we've worked closely with other experts, including Pragna Patel, Hibiscus Initiatives, Muslim Women in Prison and others, to explore these issues which do require a distinct focus. Next slide, please. The many types of criminalisation that can arise in these cases are set out in CWJ's Double Standard report and in subsequent research by Julia Pittman, Vera Baird, Advance, Agenda Alliance and others. One type is coerced offending. So coercive and controlling behaviour was made a criminal offence under the Serious Crime Act 2015, and statutory guidance notes that one example of behaviour that can constitute coercive control is where the victim is coerced into committing an offence. And yet so far, this is, as Vanessa Bettinson has termed it, a one-sided coin. If you're the unfortunate victim coerced into offending, like Elizabeth in the case study, there isn't actually a defence for you. In theory, you could rely on the common law defence of duress, but in practice, as research by Janet Lovelace and others has shown, that is unrealistic. And you're therefore reliant on the police and CPS judging that it's not in the public interest to prosecute you. If you are prosecuted, then you're starting off at an enormous disadvantage from the very beginning because you don't actually have a defence in law. Another common way in which women are criminalised is due to their use of force against their abuser. In theory, they should be able to rely on self-defence if they were acting in self-defence, but in reality, that is a really risky defence, which is unlikely to succeed for reasons that have been set out by Sophie Howes. That's partly because it's hard for women to show their use of force was reasonable, often because they're likely to have used a weapon against an unarmed abuser, even though he's likely to be physically stronger than them and capable of extreme violence. But if women are advised at all about self-defence, they're likely to be advised to play it safe and plead guilty, rather than risking conviction and a longer sentence, and that's particularly if they want to get home to children. And, you know, I've seen many examples of this in over the years in speaking to women. And one example would be Fry Martin, who killed her abuser and was persuaded to plead in her second trial, was persuaded to plead to manslaughter, specifically because she wanted to get home to her daughters. Next slide, please. So in terms of what actually leads to inappropriate arrests and prosecutions, these words are much too tiny for you to read all of that, but as well as the lack of, I've talked about some of this already, and as well as the lack of effective defences, qualitative research reveals that barriers to disclosing abuse, lack of understanding on the part of professionals of domestic abuse and other forms of VAUG, and a culture of disbelief of victim survivors all contribute to failings to protect victim survivors from inappropriate criminalisation and from wrong decision-making during criminal proceedings. And those barriers to disclosing abuse are explored in detail in the Double Standard and No Safe Space reports that we published in 2022. Even where abuse is relevant to survivors' alleged offending, and even where they are motivated to disclose it, disclosures may be limited initially, and survivors need to be given space and opportunity to expand on any abuse that they mention. This is a skilled process, as probably most of the people listening to this webinar will know. And it's particularly necessary for professionals to understand that in this context, because of course the usual dynamic in a criminal justice process is completely different from that, where that somebody is being spoken to as a suspect. The usual dynamic is that the suspect puts forward their account of events to the best of their ability, and police and prosecutors then treat that with scepticism. And that's the absolute opposite of the approach you need to assist a survivor of abuse to open up and disclose what's happened. It has to be a conscious process based on an understanding of the barriers to disclosure in order to reverse that usual dynamic and give survivors the opportunity to provide accounts that shed light on their true circumstances. But the failure to do that and to actually have a proper understanding of the context then leads to poorly informed decisions at every stage of criminal proceedings. It affects women's participation in proceedings and it affects their access to support. Next slide, please. So when it comes to experiences in court, as the Women Who Kill report makes really clear, what's at the very heart of this and sort of absolute key importance is the woman's relationship with her defence lawyer. And as others have alluded to, of course, women are the tiny minority really in criminal proceedings. And so lawyers often are not used to representing women. They're not really trained to represent women. So you're really relying on having a lawyer who has the skills and interest and aptitude to give that specialist representation, and that's not the usual run of the mill. That's not what women can generally expect. There's also the severe limits on legal aid mean that it's not actually, it's a lot to ask of a lawyer to get them to spend the time getting to know and build that trusting relationship with a woman and to really understand the context of what's happened to her. And that's just realistically, it's not likely to happen in most cases. It's also difficult to change your solicitor once you've started. So if you do happen to find a solicitor who you would prefer, it's very difficult to do that. And then when it comes to safeguards in court, safeguards do, of course, exist for vulnerable witnesses, but there's a failure to use those where the vulnerable witness is actually the defendant. So that leads to a lack of safety for defendants in court that prevents them participating effectively. In our short films, which the link is in the slides, one of the participants in the short films was Lou, she's also featured in the Double Standard report, and she's actually named as Naomi in that report. And she suffered horrendous physical and mental abuse from her ex-partner and was then prosecuted alongside him as a co-defendant, and described how she was seated next to him in court and how this contributed to her decision to plead guilty in order to avoid the trauma of going through a trial, sitting next to this man, as well as the difficulties of travelling to court and leaving her 5-year-old daughter at home. Appearing in public court in front of the abuser's family is something that featured in the Women Who Kill report, and the impossibility for women to actually talk about the abuse they experienced from the deceased in front of his family, sitting in front of them in court, that just made them feel they already felt guilty and terrible about what they had done, and then having to speak in front of the family, including children of their abuser, just proved completely impossible for them to speak openly about the abuse they had experienced. Others have spoken about the trauma of going through court proceedings, and of course, when as is often the case for women, when the offending took place in that context of abuse, the additional trauma of actually having to speak about that anyway during court proceedings. And again, in the Women Who Kill report, there are examples of women who just had to, one in particular, who just stopped giving evidence and refused to come back to court because she couldn't cope with it any longer. There's also the issue that I've mentioned of the skill needed from defence lawyers to actually draw out the evidence in a way that enables the court to understand the real context in which the alleged offence took place. There's also over-reliance on medical evidence as opposed to evidence about domestic abuse in the cultural context, and issues around substance use, both at the time of the offence and during the court proceedings. And one gap area in research is around judges and magistrates' experiences, which I think we would do well to learn more about. Next slide, please. Nearly at the end now. So different groups obviously have very distinct experiences and really do need a distinct focus. So I think it would be great to spend some time and attention on looking specifically at Black and minoritised women, and the issues that can affect disclosure and also understanding of professionals in the system, as well as migrant women. Language has been referred to already as a very basic area where serious difficulties arise in terms of participation in proceedings, as well as the interaction with immigration proceedings, and also girls and young women and the distinct experiences that affect them, and unfortunately a lack of understanding in the criminal court system of how that arises and how that should be taken into account in proceedings. And my final slide, please. So in terms of solutions, as well as legislation to provide effective defences, we need culture change and practice reform. And in fact, all of these are linked. And some really interesting points have already been made in the chat about how about sort of realistic approaches to doing this, which I hope we can discuss. Training and guidance for everybody involved in the process is obviously needed. It can always be improved, but that alone isn't going to be enough. The system needs to be set up in such a way that professionals are accountable for implementing a much more expert approach in practice, and that they're supported to do so. And obviously that women are supported to participate effectively. And women's specialist services are at the heart of all of that and really need to be built into that model. I do think that the problem-solving approaches, such as the problem-solving courts, and also the better examples of specialist domestic abuse courts like the Impact Project in Hammersmith, which have multi-agency governance underpinned by adequately funded women's specialist services, provide a really important model that I hope that we're going to be able to expand. And I'll leave it there. Thank you very much.
That was an incredibly rich and informative kind of presentation there from you, so thank you. And we've got quite a few questions in the Q&A part, so I'm going to get straight into that part and work through those systematically. So a couple of first ones for Anna. So Anna, first question is, was there anything you saw that surprised you or stood out from the court observations, either with women as defendants or witnesses?
Oh, that was not a question I was expecting. Anything that surprised me, to be fair, kind of in contrary to everything, the court observations were actually really positive, probably in contrary to what we were expecting. It was really positive to see how magistrates and judges spoke to women and took the time to sort of explain the processes and make sure that they were speaking directly to women, that they, there were several instances where women were asked if they could attend the next day of court, if there was any reason they couldn't, and they seemed to be quite flexible around if women had childcare responsibilities and things like that. I know some colleagues did see different things in courts elsewhere, but generally it was really, really positive, and just shows how simply just doing those kind of key parts of procedural fairness, and really just treating the person that's there as a defendant as a person, and ensuring that they're just as included as anyone else, how important that is.
Did that sound like that was a bit of was that specific to a certain court then? Did it feel like there'd been a bit of a cultural sort of change there, or adoption of some of those practices, potentially?
Yeah, I think to be fair, most of the observations we did were in one court in London. So yeah, definitely that's potentially how it was there. When I had visited other courts, or colleagues had visited other courts, they kind of reported it had not been quite the same. So I think it definitely seems to depend. I'm not sure what caused that kind of cultural thing, or where that had sort of come from. And hopefully maybe that means that there is a sort of general shift in things, but not too sure.
Thanks, Anna. Thank you. And another one for you, which is, can you say a bit more about the court advice service that was specifically for women that had lost its funding?
Yeah, so I only found out a little bit more about it recently, but so what I understand is they'd been running, it was a court in West London, in the west of England. They'd been running for about 6 years, and they'd supported tons of women during that time. And I think we'd sort of discovered them because we'd found some research where they were comparing it to general liaison and diversion services, where they were obviously supporting all genders, but this kind of women-specific approach seemed to more women wanting to engage with it, and it was just by it being a women-only space, somehow that meant that more women were up for engaging with it, and they were comparing it to the L&D service that were getting a lot less uptake. So whatever they were doing differently was obviously working. But yeah, they recently got in contact and said that they'd thought that they'd been funded for a long time and lost the funding, and unfortunately had to close. I think it was over 100 cases that they had, active cases that they were still supporting. with no kind of onward referrals anywhere. So yeah, it was a shame.
Yeah, that sounds like a huge shame. It speaks a lot to what Katy was saying around the well-resourced kind of additional services that are supported, isn't it? And be that women's centres and others that are kind of providing that additional specialist support that's needed. Thank you. There's a question here from Janet around problem-solving courts, and so Katy, this is maybe one that's really good for you, or anyone, Lucy, if you want to chip in as well. But problem-solving courts will always represent a resource issue, especially with court time. Should we focus instead on justifying the wraparound sentence services which have proved so successful in the problem-solving courts? Value of reports for all women doesn't necessitate a special court, but does necessitate probation funding.
Yeah, no, I thought that was a really interesting point and question, because the difficulty is, well, it's a number of things, but I suppose what you really need is, and what the problem-solving court model kind of embodies, is you need really strong working relationships between the court, the women's services, the local authority, the police, all of the different probation, obviously, all of those agencies need really strong working relationships, and they need strong commissioning. So they need to have funding for those services that repeats and is sustainable. And I think what the person asking the question is alluding to is, so if we can't have a problem-solving court everywhere, can we sort of simply make sure that sentencers know about the services that there are in the community, that the services are there, and that those services can then be relied upon, and sentences can have confidence in them to give us community order, for example, and allow women to stay in their community while serving their sentence. And of course that's right, but I know how challenging. I've seen women's services sort of working really hard to try and constantly raise awareness amongst sentencers, as well as amongst the police and others, about their service and about the impact and about the need for a women's specific approach. And it's drawing on, they've already barely got enough resources to keep the service going without doing that. So it's so hard for them to keep doing that, and they have to do it constantly. So I think you need a structure that everybody's part of. You need it to be a multi-agency governance, so that those agencies have already got together and agreed, no, look, we get it. It's part of our, it's part of our joint working that we're committed to this approach. And you need that strong relationship. And so I don't know, I don't think there's probably a single answer to how you achieve that in local communities. Problem-solving courts is one way that I've seen it happen, because if you're working on a joint project like that, you've got to get together, you've got to get to know each other, you've got to work together. But I agree, it's something we need to be constantly looking at to work out how we achieve that in every local area.
Thanks, Janet. Yeah, I think it's the difficulty, isn't it, around particularly probation, and the sort of how under-resourced probation is, and being able to manage to do something additional and innovative, and that kind of side of it as well. So yeah, really difficult. We are doing some work at the centre, kind of mapping out around and working with our problem-solving court colleagues and experts that are up and down the country around looking at problem-solving courts and problem-solving approaches. So that really speaks to what you are saying there, Janet, around like some of the kind of without a full-blown problem-solving court. So we're really keen to kind of keep in contact with you around that, and others that might be interested as well. I'm going to rattle through some more of these questions. So Anna, did you see more breaches from women if they were unable to fill and engage with community sentences?
That's not really something that I came across in the research. Yeah, not something that I would be able to speak to.
And Katy, I don't know if you want to say anything about breach and women, if there's anything specific, but we do know kind of that women are kind of often more commonly breached around things, and also around civil orders and some of those breaches as well. But I don't know if you wanted to say anything extra there, Katy.
Well, no, I mean, you're absolutely right. It is something that, again, it's another area where decision making needs to be supported by good information about the woman's circumstances, isn't it? And also ensuring that she is supported, both in terms of the conditions that are applied, whether it's a community order, whether it's bail conditions or whatever it might be. So both when those conditions are set, so understanding, are we setting this woman up for a situation where she's not going to be able to comply, and also through the duration of that order, that actually there's a good, again, you're relying on a good sort of working relationship between probation and perhaps the women's services that are supporting her to be able to have that information. And I suppose that's part of it as well, is if you have that information, then it makes it easier for professionals to manage the risk that they're also dealing with, if you're talking about breaches, and sort of to feel confident perhaps about allowing not to breach, if they know that, no, she's got a support system there and we know what the situation is. But if you don't have that information, then it's, of course, it's much more difficult.
Thanks, Katy. Lucy, a couple of questions for you. So I'll kind of outline them, but are there any courts or areas you know that are piloting any of your recommendations already? And then a question specifically around the lack of childcare and how that might impact the result of domestic abuse cases. So was that something that you kind of saw evidence of? And then I guess sort of a last one, which is around much further up, but how are we sharing some of these recommendations with policymakers and legal professionals? And that might speak a bit more widely to Anna and Katy's work too.
Yeah, so starting with the pilots, I didn't see any sort of formal pilots existing. Where there were positive examples of the courts responding to women's, it was really that individual. It was that individual judge that was able to give a court order for the woman's home to do a pre-sentence report with probation, or it was an individual solicitor that was able to rearrange the hearing of a woman on the day that her child was unwell. But I mean, we've spoken a lot about it already, but really the one thing that came through where there was a system response and a system providing support was through these advice services. CAS Plus, which operates in Devon and Cornwall, were an absolute invaluable source of support for the women who I'd interviewed in that area. And for the example of the woman I spoke to who left court to go and pick up her children despite knowing she could face arrest, it was CAS Plus that she had the number in her pocket, gave them a call, and they were able to arrange it. They were able to intervene, and she wasn't charged for responding from court. So that was absolutely invaluable support to her. But as we've spoken about, only existing in small parts of the country, vulnerable to closing. So in an ideal world where money doesn't matter, national rollout of these advice support services is really would be a good long-term goal.
Thanks, Lucy.
Yeah, I can then turn to the question around victim survivors of domestic abuse. So really interestingly, the two women I spoke to who were witnesses were both witnesses in the trial of the father of their children. And it was a case around domestic abuse that they had experienced. And I wouldn't necessarily be able to speak about how their childcare issues impacted the results of their case, but they certainly spoke about it putting a lot of more pressure on what was already a very difficult experience. We heard from the woman saying, it's just another thing I had to worry about arranging childcare so that I could give evidence in this trial, which is always very difficult. And yeah, I was quite maybe surprised about how they had a similar experience to the defendants, that there was a real lack of responsiveness to their childcare needs. I think the one difference is that they were asked whether they would be in the country on the date of the trial. That was it. Other than that, it wasn't taken into account. The example I gave of the woman who sister was asked to take a week off work and was laughed at for requesting a creche service. She was a witness and a victim survivor of domestic abuse. So there's certainly more that the court system can be doing to support women in that situation.
Thanks, Lucy. And then in terms of, I guess, recommendations, etc. So, I mean, at the centre, we are fairly well plugged into. We work closely with kind of civil servants and are always keen and have found them to be very receptive to recommendations and policy recommendations. They might not all get taken up, but we are obviously really keen to pass those on. And obviously, Katy, as we said at the beginning, is a member of the Women's Justice Board. So hopefully, does have that direct line in as well, and is, as such an expert in this field and with those other colleagues that are on that board, and the kind of implementate the secondary board as well that works alongside that. So hopefully to, I guess, maybe end us on a positive note when for lots of us this is quite depressing when we've worked in this field for a number of years and these same issues come up and up again. But perhaps with the government's kind of commitments around some of this and establishment of groups and willingness to listen to some of those experts, perhaps there is a bit of a light at the tunnel where we can try to push through some of these solutions to these issues that we've been talking about. Perhaps perhaps, I say, we will see. We have got about 2 minutes left, so we're going to wrap up there. I know there's some other excellent questions that had come through, but unfortunately, I don't want to keep you all from lunch or whatever it is that you're getting off to. I think Miranda has put in the chat that we will be sharing the recording of the event, so that will be sent round, and I think slides will be made available too, but someone will correct me if I'm wrong on that one. And please do, in the meantime, you can sign up to our newsletter to hear about other events, and Katy had kind of linked to some excellent resources that she's been part of developing as well that you should definitely check out. And just a massive thank you to our 3 speakers. That was incredibly informative and interesting discussion there. So thank you to you 3 as well.